in a couple of weeks for people who weren't able to attend and are still interested in learning and listening to follow up on. Also, if you're interested in asking a question, there'll be time at the end for some Q&A. So either raise your hand or put it into the chat if you can't speak. And I'll just read it out to the hosts and the speakers. So this is the first session that Youth GARN Hub will be hosting. This is a panel discussion, and it'll be led by Natalia, Somabha, and Lauren Tarr. So Natalia Greene is part of the International Rights of Nature Tribunal Secretariat. We're very excited to have her today. She's a consultant also for the Rights of Nature with Pachamama Alliance and is a focal point in the Ecuador for the Global Alliance for the Rights of Nature. She also graduated from Hampshire College and holds political science master's degrees and master's degrees also on climate change. And she's also just actively promoting the recognition of rights of nature in Ecuador's constitution. Lauren Tarr, welcome again also. She joined Youth GARN Hub in 2020 and has been serving as the hub's governance facilitator for 2021. So she also joins GARN from the United States, where she's an environmental policy PhD candidate at the State University of New York, SUNY. Her research focuses on rights of nature, environmental justice, and community-based conservation. In addition to her studies, Lauren has also worked as an environmental educator and English teacher for several years. Somabha is a governance facilitator for Youth GARN this year. She's a doctoral student at the University Junior Research Fellow at the West Bengal National University for Juridical Sciences. And she's actively pursuing research and activism on transgender law and their rights. She's also a member of the World Youths for Climate Justice and is passionately working on rights of nature, where she also serves in the advisory board for various organizations. She also sometimes lectures for summer courses at the Earth Law Center, which I also saw her there. So yeah, I would just like to give the stage to you guys, and I'm really looking forward to hearing what you guys have to say.
Awesome. Thank you, Bianca. And thank you, everybody from RePeat. This has been a great week. I've attended several of the sessions and checked out your Jamboard, and it's really a lot of great discussions. So today for this session, I'll start with a quick intro, and then Somabha will kind of give us a world tour of different rights of nature laws and policies. And then Natty will end with talking about the rights of nature tribunals. And then there'll be room for questions, or time for questions. All right, does this look okay? Cool. So if you've attended the other sessions this week, I'm sure you've kind of heard this intro to rights of nature several times already, but it's always good to hear it again. A lot of these ideas are grounded in Indigenous values. So thinking about holistic, and we recognize that there are many different Indigenous peoples around the world, and each group has their own cultures and customs and stories, but a often unifying theme is a holistic interconnection with nature. There are ideas of responsibilities and relationships and reciprocity, that humans and nature are working together, we're in harmony with nature, and that humans and nature are not separate from one another. And in these two images, you can see Sky Woman up in the top left, that's over Turtle Island, and Pachamama down in the bottom right. And so then you can kind of compare that to some of our dominant legal paradigms today, where it is not grounded as much in those Indigenous values in most places. Instead, there's a big emphasis on anthropocentrism, so humans are centered. Even our environmental laws, which you'd think would be more nature-centered, still kind of prioritize how does the environment impact people is kind of the centering focus on a lot of our laws. Nature is treated as a property, as something we can own, or as a resource for us to use. Even in some environmental colleges, we'll talk about how do we manage our natural resources. It really objectifies nature as something for us to consume. And we do have rights paradigms, but those are limited to people and corporations. We allow pollution. If you get the right permit, you can pollute. So it's very anthropocentric. And environmental laws over the last few decades, it's become very frustrating for environmentalists to try and take care of nature the way that we want to within this system. So here's a quote on the bottom right from Thomas Lindsay of Community Environmental Legal Defense Fund, who I think we had some speakers from them earlier this week, talking about the only thing environmental regulation regulates is environmentalists. He said that there's never been an environmental movement in America because movements drive rights into the Constitution, but rivers and cougars and ecosystems have no rights. So around the last couple of decades, environmentalists and communities are very frustrated, and they're trying to push back against this current system to create something else. So here's our legal paradigm shift. It's under this broad umbrella of ecological jurisprudence, earth jurisprudence, earth laws, and that includes rights of nature, animal rights, criminalizing ecocide, indigenous legalities, rights of future generations. And here on the right is a textbook from the Earth Law Center that just came out. This book came out a year or so ago that covers all of these different earth laws. So side note, if your university doesn't teach earth law, here's something you can introduce to your professors and try and get incorporated. Beyond those kind of cultural values, here are some other resources you can use to think about how has the rights of nature argument been developed. So we have Christopher Stone, Should Trees Have Standing? That was in the 1970s in America. He's a lawyer. And then Thomas Berry, this is more of a theologian, has kind of a religious background talking about it. Roderick Nash is more of an environmental ethics point of view. Cormac Cullinan in South Africa, a lawyer talking about wild law. This is, I think, published in the late 90s. And he also helped start GARN. Vandana Shiva in India, talking about earth democracy, also part of GARN. This book series down the bottom right, Kinship, from the Center for Humans and Nature. That's one I'd really recommend. It's a lot of different essays from people around the world talking about what is human relationship with nature like. And Robin Wall Kimmerer and Braiding Sweetgrass, an Anishinaabe botanist, scientist, and just beautiful philosopher writer. So what is legal standing and rights of nature? This is kind of the start of our little world tour on rights of nature and timeline. So thinking back to that first book on the far left, Should Trees Have Standing by Christopher Stone, this lawyer in the US proposed this idea of, well, what if nature had standing? So standing refers to the ability to participate in a lawsuit, which nature can't do in most cases. And then there was a case in 1972 of Sierra Club versus Morton. So Sierra Club, this environmental organization in the US, was trying to stop a development on a mountain. But it went to the courts, and the court said Sierra Club is not being impacted. They're not being hurt directly, so they have no standing to stop this development. And after that ruling, the Supreme Court, one of the Supreme Court justices, he dissented, saying that Sierra Club doesn't have standing, but perhaps the mountain should. So this was in the 70s, and this is kind of the first peak of these kind of top lawyers recognizing like maybe our systems need to change. So I've highlighted a few quotes in the Chief Justice or the Supreme Court Justice's ruling, saying standing would be simplified if we had a federal rule that allowed environmental issues to be litigated in the name of, he called it an inanimate object, but in the name of nature. This suit would therefore be more properly labeled as Mineral King. That's the mountain versus Morton. And on the bottom, highlighted, the river as plaintiff speaks to the ecological unit of life that it is a part of. And then, so that kind of came out, that gave some people hope. And over the next few decades, this is again within the US context, the first rights of nature law was a small town, about 3,000 people or so, a local ordinance in Tamaqua Borough, Pennsylvania. Local municipality, they consulted with CELDF to how do they stop this toxic sewer sludge in their community. And CELDF helped them draft this ordinance banning that sludge, and also within that, recognizing the rights of that local ecosystem. And since then, across the US, there have been other communities that have passed laws like that, but they tend to be, in the US context, they tend to be challenged in court, and it's still kind of an ongoing bottom-up movement here. And then when I'm done, Somabha will show more around the world. But here's definition, if you didn't catch it in other presentations this week. What are the rights of nature? GARN defines it as nature in all its life forms has the right to exist, persist, maintain, and regenerate its vital cycles. And the Global Alliance for the Rights of Nature was founded in 2010. Over 90 people from over 90 different countries are part of it. It has well over 1,000 members. And members are a diverse network of scientists, attorneys, economists, indigenous leaders, business leaders, politicians, students, activists, a very, just a diverse group who are all interested in this paradigm shift. And within GARN, we have different thematic themes. So you could join a youth hub, academic hub, legal hub, or there's regional hubs, European, Latin America, African, indigenous. And then another thing that GARN does is rights of nature tribunals, which Natty will talk about later. And if you are interested in joining this GARN movement, you can check it out at garn.org and sign up for newsletters and join different hubs. I think that is all. So I will pass it over to Somabha now.
Thank you so much, Lauren, for giving the much needed, prelude to the discussion that we are having today. And with the hope that you can see my screen and that I'm audible and visible. So what we are trying to do today in this session is probably a lot of you have had already the chance to go through the other discussions in the past few days. But in today's session, what we are trying to do is trying to reorient all of you to the fact that there has been a lot of legal developments, and the fact that a lot of people criticize the movement, saying it's more philosophical. Is it really rooted? Is there any palpability or not? So the attempt here is to give that kind of an orientation, and that's why what I would be presenting is kind of a legal chronology that has transpired over the couple of decades post 1972, as Lauren has already given quite an elaborate explanation of how the movement began, with the scholarly writings as well as the judicial proceedings that were taking place back then. So if we look at how it has been going, how it has developed since then, this very short chart will give you an idea of what has been the discourse since 1972. So on your extreme left you have 1972, and on your extreme right it is 2021, and you can see that it is just not that there have been only scholastic developments, but you have had the developments with regard to involvement of the NGOs. You have had developments with regard to court decisions, international and regional agreements, of course, conferences, tribunals. So you have had everything. So the fact that back in 1970s, it was just a concept, it was in the ideation phase, it is no longer so. It has got its own concrete approach towards implementation, which is what is required for any domain or any ecosystem that we are trying to preserve. Here it is, of course, the peatlands that we're talking about. So you have this entire pool of jurisprudence for you to take back when you are arguing in the courts of law, in policy making, in trying to argue with the government for a particular law. It could be at the federal level, at the provincial level, at the more county level, it could be at any level. The fact of the matter is that rights of nature is the inherent right of Mother Nature, and how best can we really implement it through laws, policies, and whatever piece of document that we can use. So if I take take the discourse more from the US to the larger world view, which is what I intend to do, you would see that I would be quoting examples not from just one part of the world, but I would be quoting examples from across the world. So you have to remember that all these different jurisdictions are culturally relative, yet the golden thread that runs across all these countries that have taken some step towards recognizing rights of nature legally, the fact is that they are working towards rights of nature. That's the golden thread. So Ecuador, of course, was the breakthrough point where in the constitution of Ecuador in 2008, it is just not in the preamble, but also a couple of articles which were dedicated towards recognizing rights of nature. And here I have mentioned those provisions for you all to take back, and probably you can think about it later on. You can do a lot of introspection trying to understand that in constitutions of the world you only have preamble which talks about we the people of so and so country, we are affirming to these, we are affirming to the fact that we should have liberty, equality, so and so. Here we are talking about celebrating mother nature. We are talking about the fact that we are a vital part of our existence. So look at how foresighted the constitution of Ecuador was back in 2008, where it attempted to ingrain into the human beings this idea of harmonious existence, which is what we are appreciating and which we are taking forward through the rights of nature movement and through GARN. There in the constitution, you have Article 10, and Article 10 very categorically lays down the rights that are there, as well as the roles and responsibilities which have to be made in line with the laws vis-a-vis mother nature. So that is very, very important, because as Lauren has already given a kind of an idea of the fact that how laws are inherently anthropocentric, this is the approach where it can be ecocentric, but it is of course in recognition of the rights of both these human and non-human entities. It is not that we are only saying that human rights will take a back step and it is mother nature that we are talking about. Of course that is not the case, because we are talking about this harmonious and existence, the coexistence. At the same time, you have Chapter 7 in the Ecuadorian Constitution, which has dedicatedly had 4 different articles for Mother Nature. And it says, it defines Mother Nature as nature or Panchamama. It defines the fact that that nature has the right to be restored. And how do we do it? It has been mentioned under Article 73. Article 74 says, how can we have this coexistence appreciated more and more? And that is where we are taking forward from Ecuador in 2008 to what happened in 2010 in Bolivia. In Bolivia, we had the Declaration of Rights of Nature, where there were people from all across the world. And once again, we see that this one, unlike in Ecuador experience, where it was mostly limited to the country, here it became more of a mega scale approach, where there were nations coming in from different parts, and they were affirming, they were recognizing, and they were solemnizing this pledge that we will be taking care of Mother Nature, because Mother Earth is an indivisible living entity of interrelated, interdependent human beings with a common destiny. So you see that how we are interpreting and how we are appreciating legally this relationship, and how the world is together trying to take that paradigm shift to through Constitution. Here you have a declaration, and if we move forward, we shall see the other approaches that have taken place. So just to quickly brush through the different articles that were there, you see that Article 1 defines Mother Earth And look at the beautiful way in which we have been able to define Mother Earth with the characteristics that she has, the fact that it's unique, it's indivisible, it's self-regulating self-regulating community of interrelated interrelated beings, which includes human beings, and they sustain with their coexistence. So all the time that you see, we are talking about the co-relationship, the harmonious relationship through law, which means that law has the potential of recognizing this relationship. So law need not necessarily have to be interpreted in a way where Mother Nature is used as a resource for the benefit of human beings. It is for the benefit of both of these entities that we are talking about, which is where we are arguing for ecocentrism through the laws, which is very much a possibility, and it has been made so through these different interventions that we have had. Article 2 is one of the most interesting pieces of provisions that I resonate with so much and inspired me, and that's how I am into this movement, which deals with the inherent rights of Mother Nature. As human beings, we often learn that as human beings, you have inherent inalienable human rights. So these are the inherent inalienable rights of Mother Earth. And look at the fact that we are legally appreciating the life that exists in Mother Earth and the life that exists in the human world. So if it is the life that we are legally protecting, then what is and why is there a difference between life of a human form and life of other forms? It is the life that is being legally protected. That is what these provisions, all of which are talking about. So Article 3 deals with the obligations of the human beings towards or vis-a-vis Mother Earth, and all these sub provisions that you see, none of these are anthropocentric. If you look at it clearly, you would see that these never say that, well, you cannot pollute, you have to conserve, you have to preserve, because otherwise your life is at danger. It nowhere says that. It says that you have to respect and you have to live in harmony, so do not harm her, so that you are also in return, you are making sure that harmony is maintained. So imbalance of this ecosystem is what is being appreciated through the law. And to continue from there, if we continue the movement from 2008 to 2010, we see the rate at which the legal interventions happened escalate from 2010 onwards. We had in Belize the Belize Barrier Reef judgment, which allowed for the recognition of the right of the Belize Barrier Reef to exist and sustain itself, so that the kind of damage that was done to her is restored. So if we go back to the provisions and the articles we were referring to in the Bolivian Declaration, you would see those coming into play directly, where the right to exist, thrive, and sustain is being appreciated and was legally made enforceable. Similarly, of course, Ecuador had the constitution already, but the Vilcabamba River case became again a landmark in with regard to the fact that the constitution, the provisions were being directly used, and it was the first successful case of rights of nature where the right of the river was upheld, and the fact that once again any kind of damage that was being done to her was to be stopped. So we see that the provisions, so we see from 1972 to 2011, what happens is we had scholarly ideation, we had scholarly writings slowly taking shape in forms of laws and policies, and then slowly those being used in the judgments. So basically from ideation to implementation is where we went with rights of nature. In 2017, so going a little fast paced from 2011 to 2017, in New Zealand, probably something that all of you must have heard of, what happened with the Maori tribes, who have had a long history, and I'm not going into it. But the fact that there were legislations which recognize the right of a mountain, a river, a national park, and also recognized the rights of the Maori tribes with that of these ecosystems was very, very important. So we come out with these legislations which were specifically protecting these different ecosystems. From there, we go from 2017 to 2018. And if I come to the more recent times, what happens is we see that Israel came up with a beautiful decision, which is also known as the Gazelle Petition, where the right of the mountainous gazelle, which is an indigenous species, was recognized for the first time. And it said that through this case law, we are appealing that you protect the gazelle, you protect this indigenous species and the endangered species, because otherwise we are infringing on the right to exist of the gazelle, and of course the ecosystem would hence be hampered. Similarly, you have another very interesting decision coming from Brazil, and it was the Ibama decision, and again a very interesting one, because here it was a family which was which had a parrot, and the guardianship of the parrot was finally given to this family, which is another dimension of rights of nature, which was appreciated in or which was taken into account during the movement of the Maori tribes in New Zealand, and that was shown here as well. So you see that it could be micro level of recognizing rights of Mother Earth as well, and it need not be something where we are talking about a mega scale intervention of the government or law. It could even be case to case basis. It could even be a family being given a guardianship, as you saw in Ibama taking place. Similarly, during the same time, when you come to South Asia, we see things happening in India, in Bangladesh, and in India, we had a couple of decisions actually, where of course it has remained more of a provincial or high court level decision, and there has been a stay order from the Supreme Court. Nevertheless, the fact that the other two decisions, you see there are three decisions which were there in India, of which one of them had gone to the Supreme Court and there's a stay order, but the other two, they are still at the provincial level, which recognizes the rights of the sacred rivers of Ganga and Yamuna, the glaciers of Gangotri and Yamunotri, and also the entire region, the wildlife there, and the right of that area or include that entire ecosystem to exist was recognized, and guardianship was accorded. And this guardianship mechanism was kind of a tripartite mechanism with the government intervention as well as intervention of the people. So you see again the guardianship approach that we saw in New Zealand, flowing down to what happened in Ibama, flowing down to Muhammad Salim versus Union of India, Narayan Dutt versus Union of India, and Miglani versus Union of India as well. Similarly, in Bangladesh in 2019, which is very recently, we had the Turag River decision, where the appellate division of the Supreme Court of Bangladesh, so it was on a federal level, had said that the Turag River and all the other rivers in the country are living entities which have their own legal personhood, and they must be protected legally for that, which means, and if anyone comes from a legal background, you know that a legal person would mean you have the right to sue, you have the right to be sued, you have the right to assert your rights and be protected. So that is exactly what we're talking about, because again, if we go back to what happened in Bolivia, you see that the inherent rights of Mother Nature were being recognized, and these inherent rights which were recognized were in appreciation of the fact that it is the life that we are protecting through law. So coming down quickly and to kind of wrap up, we had very interesting decisions coming in, and not just decisions, also legislative interventions in 2020, 20 and 2021. Also 2022. So we had in Uganda, this was in 2019, where Section 4 of the National Environment Act recognized the customary traditional practices of the Bangungu community, where this bond of, again, that same bond of right with Mother Nature was appreciated, and that was taken to a different level, where legally that sought protection. Legally, they were to be protected, and this relationship was to be protected through this particular provision. So here, of course, you had the indigenous people's rights coming in as well, but that was vis-a-vis rights of Mother Nature to survive, thrive, and exist. Similarly, in Argentina in 2022, you had tabling of a proposal that seeks for regulation of rights of nature. Australia passed a new legislation in recognition of the Great Ocean Road as one of the living and integral, integrated natural entity. You also had Argentina from the International Court of Human Rights ruling. From that end, the court recognized the mutual bond between the indigenous community in Argentina, as well as mother, and of course vis-a-vis Mother Earth. So this was in the indigenous community members of the Honhat, Our Land Association versus Argentina decision, with the Inter-American Court of Human Rights. So you see, it is the Inter-American Court of Human Rights that intervened enough to say that we have to recognize the rights of this of the community with that of the rights of Mother Earth, and that relationship must be appreciated and protected. So you see that we have traveled a long distance, and we have been able to assert rights of nature legally, and we continue to do that with Canada recognizing recognizing another river in 2021, along with the community that is intrinsically involved in taking care and being the guard of the river. And of course, the most recent one being that of India in 2022, one of the provincial high courts again came up with this decision that no matter what, you have to recognize the fact that the guardianship is very important, and the fact that failure of an official of the forest to perform the duties of protecting would mean that you are disrespecting the forest, you're disrespecting Mother Earth, and she has the right to live with dignity, which you are taking away from her. So the fact of the fact and issue was entirely different, but the judge pointed out to this relationship and the fact that there is an essential need to recognize the dignity of Mother Earth. And finally, something that probably Nati will also talk about is what happened in Chile in 2022 by incorporating it in the Constitution with the Article of Principles. And it's said that individuals and peoples are interdependent with nature, and together they are inseparable whole, and that nature has rights. The state and society have the duty to protect and respect them. So look at how beautifully from 1972 to 2022, we have been able to have all these legal interventions, either through laws or through policies or through case laws, or through some movements, by the way of which we have been able to legally assert rights of nature. So I'm leaving you all with this slide where you see that there are mostly 4 different approaches, and you can choose any of the approach in your fields of activism. Wherever you're working, your organizations can think about which approach to take. It could be with the government, it could be with the judiciary, it could be at the activism level, it could be representing before the courts of law. So you have these different approaches. So all the different in brief, whatever I've tried to do in the last, I guess, 20 minutes, here you see a summary of all that divided under 4 different approaches. So I think with that, I leave it on to Natty to take it forward from there. Thank you so much.
Hello, everybody. Can you hear me?
Yep.
Yes.
Let me just share my screen so I can start. And here we go. So thank you so much for the space. I'm really excited to participate in this festival, and I'm really excited for the leadership that the youth has had during these past years. I'm really excited to see how this movement has grown so much. As we were saying, my name is Natalia Greene. And since the recognition in our constitution in Ecuador back in 2008, I've devoted my past 14 years to the work of the rights of nature. So I'm really excited to be participating today with you guys and sharing a little bit of what we have done so far. I just want to share a little bit before I go to the tribunals. That is what I have been asked, is that I want to recognize that as GARN, we have moved forward with the creation of these regional thematic hubs, and that is where the youth hub is, as part of the thematic hubs with the Indigenous Council, with the legal hub and the academic hub, but that we also have regional hubs for Latin America, for Europe, for Africa, and hopefully soon one for Asia and for North America. We are holding a gathering, and that we're really happy that I'm going to see many of you now in Siena in October, and we'll be having our first GARN assembly. So I'm very excited how this movement has grown and how this has moved forward. As Somabha was saying, 37 countries have adopted rights of nature somehow, in very different levels. As she was so precisely saying, we have countries such as Ecuador that has been able to include in their constitution. I'm actually asking you guys to root and to close your fingers and to give all your energies, because this Sunday, September 4th, Chile is going to have the vote for its constitution. So indeed, what Somabha has said, that Chile has been able to include amazing language for the provisions of rights of nature in its constitution, but that was only the draft. And Chile will be voting this Sunday for the approval or rejection, and it's not so easy. Many people, like the survey says that the rejection is over the approval, but they just closed the campaign yesterday, and it was a massive amount of people just cheering for this new constitution. So I'm just really hoping that you guys can all put your energies for this Sunday for Chile, and hopefully we'll then have the second country in the world to recognize nature as subject of rights in its constitution. And then we have, as Somabha was saying, many countries that have recognized it in local ordinances as ecosystems for rivers, for another ecosystem like the Amazon in Colombia, and in many different laws. I want to go to what I've been asked, that is the idea of the rights of nature tribunals. And we started these rights of nature tribunals back in 2013, when we realized that it wasn't enough that a country like Ecuador recognized it in its constitution. We had to move a little bit forward, because we were going for, I remember, to many conferences like Rio +20, for example, and we were talking about the rights of nature, and people were still questioning the idea, should nature have rights or not? What the rights of nature tribunals have done is that they have normalized the concept of the rights of nature. They have pretty much said, nature has rights, we recognize them. The countries that haven't recognized them yet are late in doing so, but nature has rights, and since the governments are not doing this yet, then we, the people, as civil society, have the moral and ethical responsibility to judge all these crimes against nature and against nature defenders. And that is how we created the International Rights of Nature Tribunal, really as a parallel to the war tribunal that happened in Europe right after the Second World War, where the civil society was judging war crimes because the state wasn't doing so. So it was a subsidiary role of civil society. Now, in the same instance, even Ecuador, that recognizes rights of nature, and other countries that have some sort of legislation, do not fully guarantee the rights of nature, and more so the ones that don't even recognize it. So what we have done with the Rights of Nature Tribunal is pretty much we choose a group of judges who have like a legal and moral authority recognized by civil society. For example, our first tribunal president was Vandana Shiva back in 2013. And because we all admire the work that people like Vandana, like Tom Goldtooth, Alberto Costa, Leonardo Boff, and some others that have been presidents and judges for the Rights of Nature Tribunal have done, what we have done is that we select these judges so that they can give their opinion about how these cases are rights of nature violations. And what's been amazing is that we've been able to normalize the concept and to see that, of course, the problem is not only happening in Ecuador or in the places where we have rights of nature provisions, it's a world problem, it's a systemic problem, and that we can, the perspective changes completely when we look at those problems from a rights of nature perspective. So we have done this first tribunal in Quito. We followed with a Rights of Nature tribunal in Lima, then one in Paris, then another one in Bonn. Another one was held with Europe. This one actually was held online because of the pandemic for Europe. And then we held one, first one in Chile and then one in Europe that was held online. Last year, we were able to hold the 5th International Rights of Nature Tribunal in Glasgow during the COP26. And during this COP, it was very interesting because what we focused on was on two main cases, on the false solutions to climate change and for the Amazon as a threatened living entity. So we were able to choose these two main topics and deal with these topics. And as it was very amazing to hear, to listen to all these perspectives. This tribunal was led by Leonardo Boff, who is like a really amazing thinker from Brazil, and very respected too. And this was able to cause a lot of publicity and a lot of media attention, because we were especially talking about the Amazon and how this amazing and unique ecosystem is so important for the health of the planet, and how it's a living entity and is threatened. And of course, we need to work on that. So we were actually doing that tribunal. We were asked to participate and to go and do an in situ visit. The in situ visits started back in Bonn, when the participants from Bolivia, from Tibnis, asked us to come to Bolivia. What happened then is that we had a delegation from judges, a judges delegation who went to Bolivia and went to visit Tibnis. Tibnis is a national park that is threatened with the building of a road that is going to cut right in between the national park. And President Evo Morales really wanted to promote the building of this road, although he had been the promoter of the conference and therefore the Declaration of the Rights of Mother Earth back in 2010. When this judges delegation went, it caused so much pressure to the Bolivian government and to the people, that actually part of what happened was that they were kidnapped. Our judges were kidnapped for 7 hours. They weren't able to leave, or they were trapped pretty much in a cocalero community, and that caused a lot of media attention, and that forced the government to accept a meeting with our judges. And after that meeting, he said that he was going to put a halt on the building of the road. So that was like the impact of this important visit. So understanding the impact of these visits to the territory, after Glasgow, we were asked to have a delegation going to Brazil. And actually, we just arrived from this delegation visit. We went in July 2022 to Brazil. You can see a picture here of the visit of the International Rights of Nature delegation to the Amazon. We have people like Felicio Pontes here, Belenquita Chancoso, Corman Cullinan, and some other judges, people like Ailton Krenak, and Mayal Cayapo and Alfinito were our judges, and Tom Goldtooth, he couldn't come presentially, but he was part of the delegation too. And we were able to have a 22-day visit to the territory. We were able to visit very impacting places like this mine, that is a iron mine in Marabá, in Paropebas. And we were able to see how there's a systematic destruction of the Amazon based on meat and cattling, on mining, and deforestation for big farms. And it was very, very sad to see how people have been displaced. We were able to talk to these communities who have been displaced, whose lands are being threatened by mining, by land grabbing, by big farmers that are promoting cattling. And for example, this community, this indigenous leader, she's a cacica, she's the only cacica that we have in Brazil. And we were able to meet with her. Her whole community was moved to a very small territory, and the reality of what happened in Brazil is quite shocking. So we were very lucky to be able to have this delegation. We're working on the report that is going to come out about what happened with this whole delegation. The idea is to bring attention to what is happening to the Amazon, how there's a systematic threat to this amazing ecosystem, and that there are many land defenders that are hoping to reverse this, but there's a whole system that is pushing back against the people and of course against nature. We're also planning another visit. We're planning a visit that is going to happen in early mid-January. A delegation of judges is going to go to Argentina, to Vaca Muerta. Vaca Muerta is a fracking site in the south of Argentina, and we're going to have a delegation of judges that is going to go and visit this place and do, of course, a report that will bring attention to the rights of nature violation in this Mapuche and Neuquén territory. Going a little bit to where we have been able to take this, the International Rights of Nature tribunals have been able to have important verdicts after each tribunal. These verdicts have been used as model jurisprudence for many cases. For example, actually the judge that I just showed you here, Felicio Pontes, right here, he's a prosecutor in Brazil. He was able to use one of the judgments for our tribunals in his writings against the Belo Dam in Brazil. So we are able to have these verdicts as model jurisprudence for cases, and the same has happened in Bolivia. So in Ecuador, the interesting thing is that, of course, we have been able to advance a lot, not enough. We haven't been able to stop these big ecocides like mining and oil drilling, but we have been able to have many victories. We have an observatory, juridical observatory for the rights of nature that has 56 cases in favor of rights of nature in Ecuador. Most of them are in favor of nature. And we have really amazing cases like this one that I'm showing you the picture. That is the case of Los Cedros, where the Constitutional Court ruled in favor of the rights of nature in this amazing cloud forest that is called Los Cedros, which is so biodiverse that, of course, mining, which was an activity that was allowed in this territory, was prohibited after a revision, after participation of more than 70 amicus curiae in this amazing case. And this is how we have been advancing and fighting and winning actually against mining, for example, in the national courts. Right now, we are on a trial, on a case for these two frogs, Rana nodriza confusa and Arlequino secuda, that are in intact. These two frogs are in a mining concession, and a copper mining concession, actually led by this company called Codelco from Chile. And these species were considered extinct, and they were rediscovered, but they're in the site of this mining company. So from that question that was in the chat, we have, unfortunately, we have not go to court against nature. We're going to court for nature in many options. This is one of them. We actually won this case. The mining company was able to change the thing around and have us start all over again when we just lost the first hearing. We're hoping to have the second hearing in September, in the 21st. We'll keep you posted about that. But it's very interesting to tell you how we've been applying the rights of nature in Ecuador and actually taking these species and the voice of the species of the rivers to court. And that not only for the International Rights of Nature tribunals, but also to the courts in Ecuador. And drawing on that comment of nature, I just wanted to, it reminded me of this assembly member when we were drafting our constitution in 2008 that said, are you guys going to go to court and take a volcano to court when there's an eruption because it's causing all this damage? And the problem is that, of course, we're not going to take the volcano to court. The problem is that we've been, maybe we built a city right next to the volcano, and that's not nature's fault. That's because we are invading all these territories. It's the same thing that is happening in South Africa with the baboons, for example. It's not, Cormac Cullinan is trying to protect the baboons, and it's not that the baboons are causing a harm to nature, to the people, is that the people have invaded their lands, and therefore the baboons are claiming their territory. So when we see the nature in a different perspective, then it's completely different. So I'm just gonna finish up here by giving you my contact, GARN's website, the Tribunals website, and the Observatory in Ecuador's website, and let you know that yes, indeed, we are, as Ecuador, the first constitution. As I was saying, Chile hopefully will become the second constitution. And according to that question too, there are some other nations like some countries are looking to include it, but there are some other territories like Baviera, for example, that is also rooting to include rights of nature in their constitution. So we have a lot of things happening. The movement has grown a lot, and I really encourage you all, if you're not a part of it yet, to participate in any of our hubs on or the tribunals, or be part of it and really promote and make the rights of nature a reality in your territories. Thank you so much.
Thank you so much, everybody. That was really enlightening. I think it's really great that Somabha also, we all went into these like actual concrete texts. So far, these past days have been a lot more theoretical and hearing about these texts, but we haven't actually seen or read them. So it's also really great to learn about these movements that are happening right now and getting excited for them. Yeah, also I noticed like reading these actual texts gave a lot of, life and structure to these ideas that we've been hearing. So yeah, I really appreciated that. So there was some questions in the chat already. Well, I had a question initially. I don't know if you guys know, has anyone actually done this thing that you mentioned, Natalia, of taking nature to court and suing her, or suing the entity that had been given rights?
So as I was saying, it fortunately has been always the other way around. It's been us going to court in the name of nature. But I just wanted to mention something that was not a criticism, but a fear that people had. People feared that companies, for example, will take the rights of nature and take it to court, and it will be used by companies. Indigenous people were actually afraid that companies will take that right, and it will leave them apart from their responsibility of taking cases to court. And that hasn't happened in Ecuador. After 14 years, pretty much all of the cases that we've taken to court have been with the support and maybe technical support of NGOs or any like experts, but it's always been with the involvement of the community that is directly impacted. So it has never been the other way around. And of course, it has never been the other way around to judge nature. It has been, of course, used, as you can imagine, also politically. For example, like we all hate that a jaguar is killed, for example, but the Ministry of Environment went after like an indigenous person who killed a jaguar. But we have not been able to stop the state from drilling in the Yasuni National Park that is going to kill many more jaguars. So of course you can see those like differences. We are not in the stage that we can say we're completely guaranteeing the rights of nature, but we're definitely on the right track on like the recognition and hopefully the implementation more and more.
Mm-hmm. Thank you. Do any of the other speakers maybe have something to follow up on, or? Because Tim also had a question that I can read out. Tim asked if there's already other countries that are working on implementing the rights of nature in their constitutions, I think apart from Ecuador.
Chile. So you got to watch the news this weekend to see if it passes.
Mm-hmm.
And I think other countries are thinking about it. Like I know within CELDF, they talk about that these small local things will lead up to. They want a constitutional change in the US, but it's a moonshot kind of goal. So I think other groups are thinking about it, but it just don't have as many opportunities to change the US Constitution as some other countries that do more regular reforms, I think.
Right.
So I think I'll just add on, I think Spain is also quite, they're working quite a lot in that, and they have come out with a document, with a policy document, which they are hoping to get it passed in September or early October. And of course, they have planned to take it forward at the federal level and maybe at the constitution. So that is another thing that we can keep our antennas really wide enough, because some news will be coming in soon from Spain.
This also leads me to a follow-up question. In your guys' experience, having read through all of these different declarations or constitutions with rights of nature, have you guys noticed a difference in efficacy in the level of implementation, or like writing rights of nature into a certain kind of text, so like regional or constitutional levels?
I can maybe jump in there and say that it's definitely been a learning period. We definitely have had judges, for example, who still don't understand the rights of nature, and who, fortunately now with the case that I showed you with Los Cedros, judges start to understand that they cannot fail in favor against the case just by themselves. So they need support from ecologists, from herpetologists, from like a hydrologist. They cannot judge this case by themselves like they used to do it. So that has been very interesting to see that process. But I think that I wouldn't be able to say that one is more efficient than the other, like a national constitution, local ordinance. I can definitely say that it depends a lot on the political will of the authorities, and of course on the pressure and organization of the civil society that is behind and promoting it.
Is it also maybe a bit too soon to say definitively, because a lot of them are only a couple years old? So
well, it's definitely too soon. Even for Ecuador, I think that we all wished in Ecuador, like that same year, we thought that everything was going to change, that we were going to change the country completely from one day to another. But then what we realized is that look at the human rights. There's like more than 60-70 years of the recognition of the human rights, and not all of them have been recognized yet. We're still struggling to implement rights of nature, but we are not questioning if it was a good or bad idea to declare and guarantee human rights. So that's the same thing with rights of nature. It's too soon to say for sure, but we do have like a global urgency, and we need to move fast. And the nice thing about the rights of nature is that it's taking us to a new paradigm that makes us think faster on like these radical solutions. So it's definitely too soon. It's not enough, but it's definitely the right track.
Elaine has a question as well.
Yeah, thank you so much, first of all. I have the feeling that there is more rights of nature cases in, for example, South America compared to Europe. And I was speaking with a colleague of mine the other day about rights of nature, and he is Colombian. And I was referring like, oh, I heard that in the Colombian law, there's now a rights of nature thing. And he said, yeah, Colombia, it all looks so perfect on paper, but then in reality, like it's not quite the same. And I was just wondering, like looking at all of these sort of different cases that you presented, and like also from your own knowledge, how you feel like rights of nature or rights of Mother Earth works out in practice, generally speaking, or if it's like also quite diverse, like in some cases perhaps it's integrated in the law, but then it doesn't have so many results. In other cases it has a lot of results. Like what's sort of your idea of how it plays out?
I think I'll take that quickly. And I think I mentioned something about cultural relativism while I was discussing. So I think it has to do a lot with the cultural relative aspect of each nation, and the levels of economies at times, the level of the legal developments at times, what priorities one make, so all these really make a lot of difference, I feel. Because coming from India, if I give the example of India, which is where I can share a lot more, I mean, I can share ground realities. So in India, you see the approach is yet, it will take time to do the paradigm shift. So in that kind of a scenario, and as Nati was saying, that, the judges are not really convinced. They have to have forces of a lot of, other people to say, to adjudicate on rights of nature. So it is taking a lot of time, and that is the reason basic procedural issues are being questioned in India. For example, when we had gone on appeal to the Supreme Court, by saying that there are procedural issues. So you see, what do you give preference to? So in that, the procedural aspects were given preference to, than the real problem of the fact that we are damaging the rivers and that is going to create a havoc. So it really depends, that's why I said, on what priorities are there, which part of the world you come from, what is your economic status, what is the economic status of the people around. So all these have a really a big role to play. So so that is what I would say. And it is true that it developed from this part, as in this part in the sense the western part of the world, but it has its roots in the eastern part of the world, because of the abundance of relationship that exists in the eastern part of the world with that of mother nature, I would say. But at the same time, probably developments in terms of palpable legal developments are yet to be seen in this part of the world than that of the West, also because there is that scarcity or some kind of breakage in the relationship that is being felt in the West than that in the East. Even though we are, counting, I do not know whether whether you can understand what I'm trying to say, but what I feel is that the relationship is very strongly preserved, probably even now in the eastern part of the world, which is why a lot of decisions, a lot of case laws interventions have not really happened as yet, as against the Western world, where because of developments, uh, because of various things that are taking place in the West, the relationship is being broken, which is where people are moving to the courts of law, trying to protect the relationship and the stewardship and the guardianship that they are having with the nature. So even though it is kind of impacting both both the West and the East, I think the East somewhere is still appreciating or is trying very hard to preserve that relationship as against the West. I don't know whether I could make sense out of it, but probably that I would say is the reason why we see more of case laws coming from the West and a lot of activism in the West than that in South Asia, Southeast Asia, or Asia, where it is happening, but maybe at a slower pace. If that is what was your question, Irene, I to answer it. Maybe we'll wait, but
So thanks, Somabha. We have time for one more question. I'm not sure if anybody has another question, but I certainly do. So I might I might ask. Okay. I was kind of surprised by what you said, Natalia, about judges going out and seeing for themselves whether these laws, these rights of nature were being interfered with or not being respected. So for some reason, like, I wouldn't expect judges to go out and do the research themselves. You don't often hear about that happening. Is that a typical thing with rights of nature cases? And if you could
So
speak
just to clarify, Bianca, the in situ visits that we have done is with International Rights of Nature the Judges Tribunal. Remember that this is a non-binding tribunal, so it's an ethical tribunal, and not all of our judges are lawyers or judges. They are people that we respect. They're writers, they're philosophers, they're people that we respect. So they are not in the verdicts that we do. We usually hire a lawyer to help us, and then many of the judges and from the judges assembly are lawyers and develop this verdict. But this verdict is an ethical verdict. It's not a binding verdict. So this just to explain why they do these visits. Why do we do the visits? Because when they go, for example, when they went to Tibnis, when we went to Brazil, when we're organizing the trip to Argentina, what happens is that they raise awareness, because you have really important people. In this case, for example, in Brazil, we had a Corman Queen and we had a Ailton Krenak, people who are very, very respected. And the fact that they're coming to a territory and listening to the people, they bring media and media attention to a problem that is being silenced. So that is what the tribunal does. However, when you're talking about judges, I didn't talk about this in my presentation, but we did have the Constitutional Court visiting some cases here in Ecuador. They visited the case in in the Amazon territory, I'm forgetting the name, where they did a case for a lack of consultation and the implementation of rights of nature. I remember now is Sinangoy is the name. And the Constitutional Court actually did an in situ visit to the territory to know what was happening. So that is actually something that the judges from the Constitutional Court that have been a real example for the rights of nature in Ecuador have done also in, let's say, real courts as well.
Thank you. So I guess that kind of ends our first session with Youth GARN. I would also like to remind everybody that after this is another workshop being held by the organization at 6:30. They'll be conducting a workshop drafting peatland policy. So I think it's really exciting for us to participate and evaluate existing peatland policies. We'll actually have the opportunity to practice writing using ecocentric language and brainstorm next steps for rights of peatlands policies. So I would just also like to say thank you again for everybody for attending, and we'll see each other in about an hour and a half. Thank you.
Thank you.
Thank you.